the floor substitute.
Senator has the floor.
Thank you. I'll speak to my amendment in a minute. But, ladies and gentlemen, I think we're not only talking past each other, but we have a lot of people arguing the underlying bill and not the difference between the substitute and the original proposed bill. But first of all, with regard to what you just heard, I completely disagree with what the senator from Hanover said. The original bill, not the substitute, the original bill allows the government to go into your house at the very outset without the accusation of a crime. The substitute takes care of that, because in the substitute, it says they got to bring the order to your house, put you on notice that this order has been issued, and give you an opportunity to voluntarily relinquish your firearms. If you don't give up your gun or guns, or if there's probable cause to believe you have not given up all of your guns, then you are committing a crime. It's this new crime that I pointed out on lines, I think, whatever it was, 90, 91. And at that point, a search warrant can issue. So I think the exact opposite of what the gentleman argued is the case with the substitute. Number one. Number two, with regard to the due process issues, we have built so much due process into this thing, it's a due process gym. No one's arrested. No one's arrested at the outset. Today, if Senator Peterson were to walk down to the Richmond magistrate and say that I punched him in his office, they could come and take my liberty away. They would take me down to the jail right now, my body, not my gun, but my person. To me, the government locking me up is a whole lot more big of a deal than taking an object away from me like a firearm. But maybe it isn't to other people. But I think you being locked up in jail is a little more important than your gun. The government can't do this here until putting you on notice that somebody said something, giving you a chance to cure the problem, and then after that, they can issue the search warrant. And then if they find the gun in your house, after all that, then another warrant can issue for a crime, only at that point. But today, it's a lot easier. It's easy to initiate a criminal charge. You don't get to come in and explain your side or anything else. Secondly, the search warrant in this case is issued like any other search warrant in any other case. If a police officer believes there's probable cause to believe you've committed a crime, they go to the magistrate. The magistrate listens to what the law enforcement officer says. If the magistrate thinks that the law enforcement officer has met the terms of the law, believes that whatever they've said meets the terms of probable cause, then a search warrant issues, just like any other criminal case. If you don't like how this search warrant's issued, then you don't like any search warrants for anything. Thirdly, with this bill does not tread hardly any new ground. Today, if any one of your spouses, any one of your children's, if you're not married, if your roommate walks down to the Fairfax or your local juvenile court and fills out an affidavit saying that you either struck them or that you've threatened to strike them, they don't take your gun. They kick you out of your house. The ability to live in my house, to me, is more important than whether or not I can possess an object. I think being kicked out of your house is a really big deal. And you know what? To be kicked out of your house, it doesn't require law enforcement investigation. It doesn't require the Commonwealth attorney sign off. Just any person who lives in a house can go down and say, I swear I was struck, or I swear that somebody threatened to hurt me. Not kill me, hurt me. That's all it takes. And so that's the law today. All this does is says that if you've been shown after a law enforcement investigation to be a threat to yourself or other people because of your possession of a firearm and order issues, you get a chance to surrender your gun. If you don't, there's more consequences after that. This doesn't tread a lot new ground, and it gives a lot more due process protections than we currently give people for remedies, which I personally think are a lot more severe than what is in this bill. And I think we need to adopt this substitute.
Mr. President, will the gentleman yield for a question?
Will Senator yield?
I'll yield.
Senator yield, you have the floor.
Thank you, Mr. President. I'd ask the gentleman from Eastern Fairfax, do we have a constitutional right in this country and in Virginia to invoke our Fifth Amendment right against self-incrimination?
Senator has the floor.
You have a Fifth Amendment right. I would answer the gentleman and say you have a Fifth Amendment right not to invoke your right against self-incrimination after being interrogated by a law enforcement officer
I believe that answer is yes.
while in custody.
Oh.
Good point.
Further
Yes.
question?
Mr. President, another question.
Was Senator Yield?
Mr.
yield.
President, but let
Senator
me ask you a
Yield.
different way, Mr. President. If I'm driving down the road and an officer stops me and says, "Sir, I smell alcohol. Have you been drinking?" Do you have any obligation to answer that officer?
Senator has the floor.
Absolutely not.
Absolutely not. Thank you. Mr.
question?
President, another question.
Senator Yield?
I'll yield.
Senator Yield.
Do we also in this country, in this state, have an unconditional right under the Sixth Amendment to ask for assistance of counsel?
Senator has the floor.
Mr. President, what I would say to the gentleman is that according to the U.S. Constitution, it was something versus Alabama. I think you have the right to counsel if you are charged with a criminal offense in which you face the possibility of incarceration. Not every crime you're charged with.
Further question?
An additional question, Mr.
Senator
President.
Yield?
I'll yield.
Senator Yield, you have the floor.
So I'd ask the gentleman from Eastern Fairfax, if I am the individual to which the substantial risk order has been issued, and I'm at my home and the officer comes to the door and knocks on it and I answer it and he says, "Sir, I've got an order here from a magistrate that says you're a risk of personal injury," which is really what this says. So it could be that I'm a risk of bruising my own thumb under your substitute. And I look at that officer and I say, "Officer, I don't care to answer any questions of yours under the Fifth Amendment. And I really want to talk to a lawyer before I do under the Sixth Amendment." Have I not just committed a crime under that magistrate's order?
Senator has the floor.
Mr. President, what I would say is, first of all, I think it takes a little bit more than I might injure my thumb. The actual language says, upon a finding to believe there's probable cause to believe a person poses substantial risk of personal injury to himself or others in the near future by such person's possession or acquisition of a firearm. And so, I mean, I guess you could bruise your thumb by possessing a firearm, but it would be pretty hard. I think it's pretty clear the statutes talk about other kinds of harm. But anyway, having said that, I would say that if the person if all they said was, "I'm not answering any questions," if that's all they said, I would think they would be at risk. They would be at risk for a search warrant being issued. But I would note that the U.S. Supreme Court has also held that the Fifth Amendment does not cover conduct. So, for example, field sobriety exercises when you have to touch your nose and walk around and all that kind of stuff isn't covered because it's not words that come out of your mouth. And so, failing to surrender a firearm is not a Fifth Amendment speech. It's an action, and it's not protected by the Fifth Amendment.
President, another question.
Further question? Senator Yield?
I'll try this a different way. In the same scenario, when I answer the door and the officer says, "Sir, I've got an order here from a magistrate directing you to voluntarily relinquish any firearms and to turn them over me right now." That's the same as a court order. And I say, "I'm not talking to you or answering any of your questions. I refuse to comply," which I have the right to do under any other scenario under the law. Have I not just violated a court order?
Senator has the floor.
I would say that saying I'm not going to talk to you is not a violation of the court order. I refuse to comply would be a violation of the court order.
Mr. President,
Further question?
I'll yield.
I ask the gentleman again, is that not a crime?
Senator has the floor.
Mr. President, what I would say to the gentleman is that the crime is set forth in line 91, which says that it's unlawful for a person who's subject to an emergency substantial risk order to purchase, possess, or transport any firearm while the order is in effect. And so what I would say to the gentleman is that if the person continues to possess a firearm, that would be a violation of the law. And as I said earlier, simply having a gun in your house, simply having something in your house is not possession. If you asked me to detail every object in my car or in my house today, I couldn't answer that question. The government has to show that you know the item's there, that you know what it is. If it's in a box, it could be a box. You don't know what's in the box, but you have to show it that it's there, what it is, and they have to show that it's subject to your dominion or control in a criminal proceeding. And so, as I said earlier, I think if a person failed to surrender a gun, they would be at risk for being charged. But I'm not going to sit here and say on the floor that they're 100% absolutely, positively, definitely guilty of a crime.
Further question?
I'd like to speak to it if I may, Mr. President.
Senator has the floor.
Thank you, Mr. President. Again,